Hi, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. I would like to talk about how an average lawsuit progresses, but first I just want to say if you have any business litigation needs, want to discuss anything you hear in my video, or would just like to chat in general about your business, all you have to do is go to jdelaw.nyc/consult. That's JDELAW.nyc/consult. And you can schedule a 10-minute phone or a 30-minute in-person consultation. Now, first, I want to explain how a lawsuit really progresses for the average person. All right. So, we'll take it from the plaintiff's side first. The plaintiff is the person who initiates a lawsuit. The first thing that happens is, of course, the plaintiff comes in, speaks with an attorney, says, I have this kind of case, and then the attorney looks over all the information. They draft what's called a summons and complaint. And what the summons does, it lets people know that there is a lawsuit, and the complaint lets them know what it's about. And so then the summons complaint gets sent to a process server to serve the defendant, the person who's being sued. At that point, what happens is the defendant has a couple options. The defendant can either answer the complaint, which is a formal document called an answer, or they can file what's called a motion to dismiss the case. The motion to dismiss basically will say this lawsuit, they can't possibly win. For example, let's just say it's a fraud lawsuit. A fraud lawsuit has to do the who, what, when, why, and where of the lawsuit, of how and when the fraud occurred. So, if the complaint doesn't have that, you make a motion to dismiss saying that the case was not properly pled in the complaint, okay? So, those are the two options. The defendant can answer, really, or they could file a motion to dismiss. Now, let's assume, for the sake of argument, that the case, that an answer was filed. Now, the next step is you entered what I call the discovery phase. Okay, this includes going to court for conferences, exchanging documents, trying to figure out each side's, legal positioning. And then you also do what's called depositions, which is where, the plaintiff and then the defendant, they have to sit down with the attorneys and a court reporter. And basically the opposing counsel gets to ask questions. Now, this is kind of a run-up for trial. You want to find out what the person's going to say, how they react to questioning, things like that. So it's kind of an interview for trial. How is a person going to act? And you get information. Plus, the deposition also locks down a person's point of view, for what they're going to say. Now, if they say the sky was blue that day, and then for whatever reason at trial they say the sky was red, you can say, well, didn't you say at the deposition that the sky was blue? So that is the purpose of the deposition. After that, what happens is that you certify for trial once the discovery phase is complete. And you say, we are ready to go to trial. At that point, a note of issue is filed by the plaintiff saying we are ready for trial. It's an official document. And usually the defendant or the plaintiff, they have 60 days to make a motion for summary judgment. Now, a motion for summary judgment is a motion that states we should win without the purpose of a trial, because based on the documents or based on everything, in this case, we would win no matter what. That's the purpose of a motion for summary judgment. Either side can file it. And once that's done, again, let's assume the motions for summary judgment get denied. Okay, then you go to the settlement part. Now, this is very New York specific, but in general, what happens at the settlement part is that you go in front of a judge, and the judge tries to get the sides to come together to settle it so they don't have to waste the time with the trial. If it doesn't settle, then you're going to trial. And that's where you lay everything on the line. You have witnesses, you're in front of a judge, possibly a jury, depending on the case, and you put it all out there. And then you get a decision. So that's the basics of how a lawsuit works from start to finish. Those are kind of the steps. There's a lot of variables that get thrown in there, other kinds of motions that can be made, but the average lawsuit progresses at that pace. And that pace usually takes 1 to 2 years, probably, just to do what we talked about. Now, what happens after you get a judgment, just to let you know, is the case either gets, hey, the defendant wins, that's what gets said, and the case is over. Where the plaintiff wins, they get a money judgment that they have to chase. Once they get the money, case is over. And of course, settlements happen anywhere from the start to finish of the case. It's very rare that a case does go to trial because it usually settles somewhere along the way. Sometimes immediately, and sometimes as you are about to start your opening argument for trial. Like I said, it could be anywhere in between. So once, like I said, settlements prevent trials, or they stop it from getting to the trial phase. And like I said, that is really the start to finish of an average lawsuit. Okay? But like I said, the average lawsuit settles before it gets to the trial period, so just keep that in mind. Now, if you want to discuss this further, want to know more about business litigation, and would like to discuss your case, possible case, or you just want to chat about your business, please just go to jdelaw.nyc/consult. That's jdelaw.nyc/consult. And you can book that 10-minute phone or 30-minute in-person consultation. Once again, I am Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Thanks again for watching.